Hello, everybody. My name is TJ Scott, and I'm an estate planning attorney located in Bloomington, Minnesota. I'm also the owner of the law office of Timothy J. Scott, and I'm very happy to have you joining me here tonight. We have a number of attendees already here. More people I expect will also be filing in here. I know tonight we're going to be talking about a difficult topic. We're going to be talking about death, and we're going to be talking about end of life and what that looks like and what that means. But I want to empower you tonight. I want to give you the knowledge so that you don't have to be afraid of this topic, so that you can know exactly what you need to do to get a plan in place that takes care of your family and that takes care of the people that you love. So today I have some really valuable information that I want to share with you. I hope that you'll stick with me all the way to the end of the presentation. The best way to be here with me tonight is to dedicate this time to learning about wills, trusts, guardianship, estate planning in general. So I encourage you, if you have the TV on or if you have another tab open, I encourage you to shut those down and just give yourself the time that you've already dedicated to being here with me tonight. And I always say your future self is going to be glad that you took the time to learn this information and educate yourself. And if you stick around until the end, I have some fantastic offers that I want to make you. One of those offers is how you can get a free virtual one-on-one meeting with me where we can talk about your specific situation. We can talk about your assets and the people that you love and how you can do your best to protect them and keep them safe at the end of your life. We'll also talk about, I'm going to offer a bonus gift that makes it even easier to get a great tailored custom estate plan written for you at a discounted rate. So please stick with me until the end. I promise you it's going to be worth it here tonight. So we're going to have a little bit of audience participation. We already have had some audience participation in the chat, and thank you for sharing with me if you have where you're coming from, where you're joining me from. I am going to pop up a poll here right now, and the poll question is this: do you have an estate plan? The elements on here are all part of a good estate plan. That a trust is often included in an estate plan. A will is probably the most commonly thought of instrument in an estate plan. If you have minor kids, guardianship nominations for them is really important. Healthcare directives and powers of attorney, plan for if you're incapacitated, and then beneficiary designations are an essential part of every estate plan that they factor into it every time. And I'm seeing here a predominance of no, that most people do not have an estate plan that are here tonight. And I really appreciate you sharing that information with me. And that brings up another question, which is, if you don't have an estate plan in place, first off, don't feel like you're unusual. Because right now, something like 68% of Americans don't have an estate plan in place. But maybe you have a reason why that you want to share with me today. I'm going to launch this poll here. Let me know if something on here resonates with you. Maybe you feel like you're too busy. And trust me, as a father of 4 young kids and an entrepreneur and somebody who owns a business, I completely understand. Life is very busy. If that's the case for you, just want to congratulate you on being here tonight and dedicating the time to learn about this topic here tonight. Maybe you feel like you're too young. And the reality is that everybody should have an estate plan in place once you turn 18 years of age or older. I showed you some of the elements of an estate plan on the previous page. And a trust and a will, a lot of times that's what people think an estate plan is all about. But estate planning also includes planning for incapacity, planning to make sure that somebody could make decisions for you, deal with your finances, deal with your health if you can't deal with those things yourself. Maybe you feel like estate planning is going to be too expensive. And trust me, again, as a father of 4, I completely understand that feeling that this is something that is going to cost me too much. It's not something that I can do right now. Maybe I'll be in a better financial position in the future and deal with it then. If that's the case for you, I just want to encourage you, there's never been a time when estate planning has been as affordable and as approachable. Used to be with an estate plan, you had to file everything, you had to fill everything out in triplicate, those carbon copy forms. And if you made any mistakes as you were writing out that complicated will, you'd have to tear everything back up and start fresh. But with word processors, truly estate planning is for everybody. It's for the middle class, it's for everybody now. And again, it's never been more affordable, more approachable than it is today. And I see somebody fessing up that they are worried about jinxing themselves. And sometimes people don't admit that, but it's something that's pretty natural to us, that we have this feeling that, we see enough TV shows, the police officer dies the day before he retires or whatever the case is, that it would just be right, wouldn't it? That as soon as I went out and got an estate plan in place, something bad would happen to me. But I can tell you, I have written dozens of estate plans. I've written hundreds of estate plans, and I have never seen a correlation between somebody getting their estate plan done and having something bad happen to them. It just doesn't happen. I always say, I think my clients tend to live without that weight on their shoulders. And so they tend to live more intentionally. They tend to live without that burden, without that distraction in their lives. So I always think my clients have less of a chance of something negative happening to them. So I saw that there were some people who have an estate plan in place right now. And if that's you, fantastic. I'm curious, what do you want to learn here tonight? And even if you don't have an estate plan in place, is there something on here that resonates with you? Maybe you did a will, but it's been a long time and you're wondering, you're wondering if maybe it's outdated, or maybe you were thinking about doing a do-it-yourself or an online will, and you want to know, is this going to work for me? Is it going to take care of my family in the way that I want my family to be taken care of? Maybe you're just curious about this. You have heard that you should have an estate plan in place, but you don't really know much about it, and you just want to get a better understanding for estate planning, or maybe you want to have a better understanding of what's already in your estate plan, that you wrote an estate plan, but the attorney didn't describe it well, or didn't bring you along in the process. And now you're not sure if it's going to work for you. You're not sure if it's going to take care of the people that you love in the way that you want them to be taken care of. And go ahead and put it in the chat. If you came here with a specific question tonight that you want to make sure that I address, I really encourage you to either put it in the chat or put it in the Q&A box so that I can see it and I can speak directly to that question tonight. The reality is you are in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or fill in the blank will, or you're considering doing a do-it-yourself or online will, but you're not sure if it's going to work for your family. And you're in the right place if you're nervous about how much this is going to cost. Again, I'm a father of 4, completely understand how important it is to use the money that you have coming in for the best purposes. And I promise you that it is more affordable than it ever has been and more approachable than it ever has been in the past. So thank you for being here with me tonight. The reality is estate planning isn't about you. It's about the people that you love. And these are 3 of my 4 kids. We don't have the youngest picture here yet, but I promise she'll make an appearance later in the presentation here today. From left to right, this is Margaret, Ben, and Elizabeth. And this was something that really occurred to us as we were recently updating our estate plan, that your loved ones are going to know whether or not you lived up to your promise to take care of it. And that really struck us, that our kids are going to know if we have a plan in place that's going to take care of them. And that's who we were doing it for. That's who we were making sure we were taking care of. It was really a gift to them, a gift to make sure that they're well taken care of. I do see a question coming in here, a couple of questions coming in here. One question I see is, how much does it cost just to do a trust or will for our kids? Does this apply to the house that we are currently in, or apply to future houses too? For example, 10 years from now, if I purchase a new home, does that mean that I have to pay for a new estate plan? And then I have another question, cost for just a trust/will to make sure our kids inherit our home. And these are fantastic questions, and I'm definitely going to speak directly to the cost that you can expect to pay for an estate plan here this evening, because I know that weighs on a lot of our minds. I can promise you as much as possible that it is more affordable and more approachable, but unless I actually tell you the numbers, that's just whistling Dixie, I think. So I will speak directly to that here tonight, I promise. I will speak exactly to how you can make sure and make it as affordable as possible. Another question I have here is, recently divorced with a minor child. I want to protect every asset, especially the home, for my son. And absolutely, that is, I completely understand that situation. I've worked with many people in the exact same situation, and that's definitely something that we can do. That's something that is very much a part of estate planning, is securing those assets, stewarding them to the people that you want to receive so that they're able to receive everything that you want them to have. Very good questions. I promise that we will be addressing everything in depth and in detail here as we go about our evening tonight. In fact, these are the things that we're going to focus on tonight. We're going to focus on planning for incapacity, who can make healthcare decisions for you, who can make financial decisions for you. We're also going to talk about planning for when you pass away, and that might mean guardianship if you have minor kids. In fact, I'm going to post one more poll here, kind of a demographic poll to see how many people there are with young kids, because truly guardianship, the way that I'm going to talk about it here tonight, is really focused on people with kids under the age of 18, minor children. We're definitely going to talk about probate here tonight. We're going to talk about the time, cost, and public nature of probate. We'll also talk about estate taxes. Estate taxes is generally where I get to give people some good news, which you don't always get to do as an estate planning attorney or somebody in this area. We'll talk about unclaimed property and what that is and how you can protect your money from the Minnesota Department of Unclaimed Property. We'll also talk about intangible assets, things like your values and stories that you might want to share with the people that come behind you. Thank you everybody for sharing. I see here, did you say you are going to focus on people with kids? If yes, maybe I should not listen. Absolutely not. No, this isn't just focused on people with kids. The guardianship element is just for people with minor kids. And so because I'm not seeing a lot of people who have minor kids in particular, I am going to spend a little bit of time talking about it, but not as much time as we'll spend talking about probate, for example, or unclaimed property. So no, the focus won't be on minor kids here tonight. It will just be a part of what we're talking about. I see here another question. I don't have kids, want to leave everything I have when I pass to a chosen nonprofit. That's fantastic. It's a charitable desire, and that's definitely something that you can accomplish with estate planning and accomplish in some creative ways too. There's some creative ways to accomplish that. Great. Thank you everybody for sharing with me and interacting with me. And I hope that you're seeing if you have a question, it's likely a question that somebody else here has. So I hope that you'll speak up and share it with everybody so that I can answer that question for you. All right. Before we start on those topics, I want to share just a little bit more about me. So since we're going to be spending some time here together tonight, this is me and this is my family, and we live in Bloomington, Minnesota. My family is my whole world. I spend a ton of time with my family and taking care of them. This is my wife, Tobin, and then the kids here, this time from left to right, are Elizabeth, Margaret, Bridget is the baby, and then Ben is my son, and he's 11 years old now. I graduated from law school back in 2012 on May 12th. I graduated near the top of my class on law review, and the very next day, May 13th, my son was born. After law school, I found a job with a small estate planning and tax preparation law firm in Minneapolis, and I loved my time there. I was able to learn a lot under Judy Martin, who was an attorney with a lot of experience, 30 plus years of experience in estate planning. And she taught me a lot about how to write a good estate plan. At the same time, there were some things that I thought that we could do different there. And this is actually a quote that I heard somebody speak, not about me. This wasn't said about me, but this was said about another estate planning attorney. It wasn't said about Judy Martin either. Said about another estate planning attorney where somebody had had a very negative experience working with this estate planning attorney. And the reason that they'd had such a negative experience was because this attorney was practicing under a very traditional model of estate planning, a very old model of estate planning. They were focused on some things that maybe weren't conducive to writing a good estate plan that took care of the family and that kept the family out of court and conflict. And I remember these people saying someone had to graduate at the bottom of the class. But I don't think it was this attorney's knowledge. I don't think it was this attorney's intelligence. but actually led the person to say this. I think that it was a struggle with that traditional model of estate planning and putting priorities in the wrong place. And I'll talk a little bit more about that here as we continue on tonight. So I did see there's somebody with a minor child here tonight, and I do want to speak to this a little bit, but I promise you I'm going to speak very briefly about guardianship and then continue on, and we'll spend more time in some of the other areas. What I want you to know is this: if you have minor kids, choosing guardians for after if something happens to you is very important. Short-term guardians would take care of your kids in the short term, maybe up to a week or 2 weeks until the long-term guardians can get in place. But it's very important. And the story here is if you went out and you left the kids with a babysitter and you didn't have a plan in place, what would happen if you didn't come home? Eventually, the police would be called. The police would bring in child protective services. And that's just to protect the police, really. It's to protect everybody, to make sure that that the kids are with an authority who can actually stay with them. And I can tell you, this is no knock on child protective services, but I don't want my kids staying with child protective services for any time at all. And so this is not an option for me, which is why I have short-term guardians in place who are legally documented and can stay with my minor children if something were to happen to my wife and I, that they would be able to stay with the kids for a time until the long-term guardians could be contacted and the kids could get to be with the long-term guardians. And those long-term guardians take care of the kids and raise the kids until the age of 18. And that's where it's really important to have somebody in place, someone that you know is going to take care of the kids and is going to be a place where the kids are going to flourish as they grow and as they mature into becoming adults. If you don't have a plan in place, then the plan is that a judge is going to decide who's going to take the kids. And it might not be who you would prefer to have the kids. I always say maybe Uncle Larry checks all the boxes. Maybe Uncle Larry has a steady job and has a home with room for the kids, and therefore the judge is going to say Uncle Larry should have the kids, even though you know Uncle Larry should be the last person to have the kids. And I actually worked with a client named Larry, and he said, "Stop using Larry as the name, stop it." But you could imagine maybe it's Uncle Brian, maybe it's Uncle Brad, or maybe it's Aunt, whoever it is. It might be a person that you don't want having the kids. All right, that's the end of the guardianship discussion. I see here another question. I don't have family and I'm struggling with the disposal of assets. And that's really hard, that maybe you don't have kids and maybe you're not married and maybe you don't have grandkids and great grandkids. And that's really where the state looks first, and the state thinks that you want your assets to go to those kids, grandkids, great grandkids. But that's not the reality for all of us. That for some of us, we don't have that natural succession plan. So where are the assets going to go? And maybe it's in the family. Maybe there are friends who have become family. Maybe there are charitable wishes that you have. And I know somebody shared that earlier, is that they have some charitable interests in nonprofits that they want to receive the assets. That's very much a part of the estate planning conversation that we have together, is who's going to receive your assets and what do you want it to look like when they receive your assets? So that's a fantastic question and a reality for a lot of us that I really appreciate whoever shared that question. How will they receive your assets? This is if you have an estate plan in place, or if you don't have an estate plan in place, or if your estate plan is based on a will-based plan, then this is the state's estate plan for you. Essentially, kind of like I said, the people who have a right to receive, who are going to have a right to receive, would be children. Maybe your spouse would have some say over your assets first, then your children, grandchildren, great-grandchildren. If you don't have that natural succession, if you don't have those descendants underneath you, then it would actually go up to your parents' level and brothers and sisters, nieces and nephews, grandnieces and nephews, and it would look for a descendant of your parents. If it didn't find anyone who is a descendant of your parents, it would go up to your grandparents and it would look for descendants of your grandparents. So that's aunts and uncles, first cousins once removed. It would look for somebody in that line of succession. And it even has a plan to go up to great grandparents, And I don't even know what that relation is exactly. Once you have great grandparents and you're looking at descendants there, it starts to get very complicated, as you can imagine. Once it gets to grandparents, you're starting to talk about a lot of people out there, and it can be very difficult to track down all of those people, which is why it's so important to put a plan in place to make sure that the people you want to receive your assets are able to receive your assets. But the way that those people will receive the assets is through this process, this court process called probate. And what probate is, it's essentially a lawsuit that you file against yourself with your own money for the benefit of your creditors. It sounds awful because it is awful. It's essentially a way that the state makes sure that creditors get paid after you've passed away. And in order to have somebody step into your shoes, in order to get somebody who can be named as an executor or personal representative, if you've ever heard those phrases or those names before, in order to make sure that that person can stand in your shoes and take care of your assets the way that your will says, or the way that the state's intestate statutes say that your estate should be taken care of, that person has to subject themselves to the court and the court oversight. There are a few things that people generally don't like about probate. Number one, it takes a long time to get through probate. It is a slow process. Here in Minnesota, it takes at least 6 months. Oftentimes it's taking more like 12 or 18 months to get through the process. If you own real estate, if you own your home, probate generally takes at least 4 months before you can actually prepare that house or that home for sale. It's just a very slow process. Probate's also expensive. It costs something like 3 to 6% of the gross value of your estate. And we'll actually calculate that in a little bit. It's not a tax, but it's a composite of a bunch of fees that are required to be paid out of your estate. Things like attorney's fees and executor's fees, appraisal fees, bond premiums, filing fees, and then the creditors get the bite at the apple too. Not to mention, if you own real estate, if you own assets that need to be maintained, there are utilities fees and real estate taxes, and maybe a mortgage if you still have a mortgage on the property. It's very expensive to maintain all of those assets as you're going through this lengthy court process called probate. And I see a fantastic question here. How can you do probate if you're dead? Sorry to be graphic. That's a fantastic question. It's not you, it's your estate, right? And it's other people guiding your estate through the probate process on your behalf. And generally, if you haven't named somebody, it's somebody who has an interest or stands to benefit from your estate. That might be a creditor. It might be a beneficiary who would receive some of your assets. Maybe it's a niece or nephew who would receive your assets or inherit something from your estate. And they decide to step up and say, I'm going to be the personal representative for Aunt Emma or whatever it is that the case might be. So that's generally what happens is you can't do probate, but somebody can do it for you on your behalf for your estate. And how do they get to decide who gets to do the probate? That's a fantastic question. There's a natural succession, like the intestate succession that I just went through. If you don't have a will in place, that's what they look at. The natural people would be your spouse, then any children, any grandchildren, great-grandchildren. If not there, a parent, a brother or a sister, a niece or nephew, grandniece or nephew. It follows that way and looks for somebody. If there are multiple brothers and sisters, then guess what? Everybody has an equal right to be named personal representative. And that means either that they need to fight it out over who would be the best person. They could come to an agreement that so-and-so is the oldest, for example, and is going to take care of things and guide this estate through probate. Or they could try and be co-personal representatives, which I can tell you often ends in difficulty and gridlock. Another question here is, a will the same as a trust? And no, a will is not the same as a trust. A trust can avoid probate for any assets that are in the trust. Whereas a will is a testamentary document. It only comes into being at your death, or it only is in effect at your death, unlike a trust, which can be in effect during your lifetime and can be in existence during your lifetime. And so a will needs to have that court supervision. It needs to be submitted to a court, whereas a trust can be administered without being submitted to a court by a successor trustee. All fantastic questions. I have here a couple of the comments. I have 2 grown children and 2 grown grandchildren and 1 minor grandchild. That's beautiful. That's lots of people there that you might be providing for. Someone else, have a brother and want him to have some of my money. I have 2 grown niece and nephews and would like them to have my house. That's fantastic. And for that, you really need to have an estate plan in place. Because you have a brother, your brother would be the person naturally to receive everything, assuming that there isn't somebody closer in that relation. And the niece and nephew likely wouldn't receive the house unless you have something in place, a plan in place for them to receive that asset. So thank you for sharing that with me. And thanks everybody again for all the questions. So probate takes a long time to go through. It's expensive. It's also public. And this is the last will and testament of Anna Nicole Smith. And the reason that I'm able to access this is because everything has to be public. Everything that gets submitted to the court in a probate needs to be made public. And that includes things like your will and who gets to receive under your will. It also includes things like an inventory of your assets that's created. And then a final distribution, a plan of final distribution. Who's going to receive your assets under your trust? And all of that is made public because the court has an interest in transparency and keeping matters as transparent and public as possible. And an example of this, here in Minnesota, you can actually look up the probate for Prince and see exactly who's going to, or who has now, I believe, received his assets. That it's his half brothers and sisters, and they formed 2 LLCs, and there's a whole complicated way that they're receiving. But you can see exactly what assets were going to go to them and who's receiving. All of that information is made public. Another question here: if I have a child, if the child is over 18, do the assets go to my child first in probate or my siblings first? A child would be preferred, even if the child is under the age of 18. The assets would still be held for that child until the child turned 18 under something called a conservator. And a conservator, I'll talk about that a little bit more here. But a child is always preferred. Even if a child is a minor, the child is still the preferred recipient over any siblings. Does it have to be public? Can you make it not public? Sheesh. Yeah, I know. It's kind of absurd that we make it all public, that we air everything out. Again, the court has this interest in keeping everything public, and they say that there's a transparency interest and an interest to the public so that they can see everything. But I agree with you that it seems extreme. There are ways that you can make your estate administration private, including planning with a trust. That a trust is an inherently private document, doesn't need to be submitted to the court, can be carried out by your successor trustee without supervision of the court very easily, and can keep things private. If you have a trust, is it private? Yeah. So yes, that's exactly what I was just saying and just responding to. So very good question. All right. If you have minor children, those minor kids will receive the assets at the age of 18 and completely unprotected. And that's really important if you have minor kids to make sure that you have an estate plan in place, because I think we all know stories of minors receiving assets at too young of an age, and it can be really harmful to their financial sense and how they handle money. Okay, here's a chance to calculate your probate estate. The assets in your probatable estate, or the assets in your probate estate, are assets that are in your personal name at your death. So anything that has a beneficiary designation on it passes by that beneficiary designation. If you own an asset jointly with someone else, for example, if you have somebody who is joint tenant on your home, maybe your spouse, for example, then that joint tenant, when you pass away, owns the asset outright. That asset would not have to go through probate at that point. Maybe when your joint tenant passed away, then it would have to go through probate, but it wouldn't have to go through probate just when the one joint tenant passed away. Assets that are in a trust don't have to go through probate. Assets that have a transfer on death or like I say, beneficiary designation or a pay on death designation don't have to go through probate. So a lot of the assets that, a lot of the places that we put a lot of money, things like life insurance proceeds and retirement accounts, generally have beneficiary designations on them and don't end up needing to go through probate, which is great, which is good news. But things like these, things like real estate, generally doesn't have a beneficiary designation on it. Maybe you own it jointly with a spouse, maybe you even own it jointly with a child, but if something happened to all of the joint owners, especially spouses, when something happens to the surviving spouse, that asset is going to have to pass through probate in order to get to the kids. So here we have a couple parcels of real estate, a family home and some rental property. Furniture and household goods generally have to go through probate. Things like your furniture, clothing, jewelry, firearms, those things, sports memorabilia, coin collections, those things are all personal property that needs to go through probate, generally needs to go through probate if you don't have an estate plan in place, or if you're just planning with a will. Automobiles rarely have transfer on death on them. It's possible to put transfer on death on an automobile, but it's pretty rare that I actually see that done. Stocks, bonds, bank accounts very rarely have transfer on death or beneficiary designations listed on them. It can be done, and I have seen it done with stocks and bonds and bank accounts, but it is pretty rare to see it done unless somebody has done some estate planning in the past. And then business interests. If you own your business, there are ways to, again, transfer that at your death, but it's pretty rare to see anybody have that kind of pre-planning done ahead of time before actually getting an estate plan in place. What rights does an ex-spouse have with my trust? None. If you write a trust, you don't have to include your ex-spouse at all in that trust. That by the character of your divorce, they no longer have any right to receive that they originally had in your trust, and you don't have to include them at all in that trust. Okay. Here's a little complication with minor kids. If you have beneficiary designation set or transfer on death designation set on, or if you have those beneficiaries on a life insurance or retirement account, but it's payable to a minor, then those assets have to go through conservatorship, that they can't actually go directly to that minor. Minors can't hold those kinds of assets. It would first have to go through this conservatorship, which is similar to probate, actually more expensive and time consuming than probate. How many people can be in a joint tenant? As far as I know, you can have as many people in a joint tenancy as you desire. Most often it's something like 2 people. I've seen up to 4 people before, but it's pretty rare to get more people than that. And I'm sorry, I didn't even give the calculation for calculating your probate estate. Again, here in Minnesota, we say probate is likely to cost something like 3 to 6% of the gross value of your estate. Here, I was able to get 5% of the value by moving the comma over one place. So that's $85,000, and then cutting that number in half. And that's how I got that $42,500 here as an estimated probate costs and fees on this sample probate. And again, you can just see how much that goes up if you have other assets in there. There's a foolproof way to avoid probate, and that's by fully funding a living trust. And a living trust is essentially this, that somebody owns property and they give it to another person and they say, this is what I want you to do with that property. And the person who received it says, yes, I understand. I'm going to take care of your property in the way that you've asked me to. That's a trust. It's an agreement between 2 parties. The party who starts with the property is called the settlor or the grantor, and they're giving the property to the trustee who's going to hold it and control the property during the trust period. Okay. And oftentimes when I talk about a living trust, actually, I'm talking about somebody being in both of these positions. You are the settlor, you're the grantor, you're the person who starts with the property. You are also the trustee. You're the person who is going to have control of that property during your life, but you're wearing a different hat. from wearing the fiduciary role hat of being a trustee. And so fully funding a living trust is making sure that all of the property, that all of the assets go to that trustee. So for example, if you have investment accounts, you want to make sure that those investment accounts are retitled in the name of the trust or in the name of the trustee. You want to sign new signature cards at the bank so that those assets are put into your trust. You execute deeds on real property to transfer them into the trust, transfer stock and bond certificates so that they're, again, reissued in the name of the trust. Assign personal property to the trust using an assignment of personal property, which is very simple. And change life insurance and retirement account beneficiary designations so that they actually point to the trust and pay into the trust instead of needing to go through your estate, which is really the worst situation, especially for retirement accounts. And again, this really is foolproof. You can avoid probate. You can avoid that public airing of all of your assets and who is going to receive those assets. You can avoid the time that it takes to go through probate. You can administer a trust much more quickly than you can administer an estate that has to go through the court process, through that administrative probate process. And it's much less expensive after you're gone, much less expensive to have a trust in place than to have to pay for the legal fees and court filing fees and appraisal fees and all of that stuff that has to be done if you're planning with a will only, or if you don't have an estate plan in place yet. All right, here we have a chance to calculate our estate tax. And again, this is a place where I get to give most people good news that, here in Minnesota, well, excuse me, let's talk about estate tax. On the federal level, we have an exemption, and the exemption amount is $12.92 million. That means for your first $12,920,000, you pay nothing in estate tax. For your $12,920,000 and first dollar, you start paying estate tax, and the rate goes up very quickly all the way to 40%. Needless to say, if you have over $13 million, you need to be doing some estate planning. You need to be planning and doing some estate tax planning. But obviously that applies to very few people. It's just very rare. Most of the people that I plan for were not planning for estate taxes at all. And the reason is here in Minnesota, we also have an estate tax, and the estate tax rate here in Minnesota goes up to 16%. But again, we have an exemption, and that exemption amount here in Minnesota is $3 million. So again, most people, the estate tax doesn't apply on the federal level. There are some people that it applies to on the state level, but it's rare that the estate tax applies. And again, it's not the primary reason to do planning. The primary reason to do planning, I would say, so that you can control who's going to receive your assets, that you can make sure that they're receiving the assets in the way that you want them to, not through probate. You can avoid probate and make sure that they receive assets in the simplest way possible. You can do incapacity planning, which we'll talk about in a little bit. There are lots of reasons to do estate planning beyond planning for estate tax. Another question here, is a fully funded living trust the same as an estate plan? It's a great question. An estate plan, I would say, is a comprehensive plan for incapacity and for death. And so a trust can be a really great part of an estate plan. In fact, it can be a part of an estate plan that really addresses what's going to happen when you pass away, what's going to happen with your assets when you pass away, and make sure that those assets are as secure as possible. It can also plan for incapacity, because your trustee can deal with any assets, your successor trustee can deal with any assets that are in your trust if you become incapacitated during your lifetime. But a trust is only a part of a comprehensive estate plan, that there are other documents, there are other things that we would want to see in place there. One of the primary things that I can think of that wouldn't be included in a trust, or that a trust wouldn't affect, is who could make healthcare decisions for you if you can't make them for yourself. And beyond that, what kind of healthcare decisions would you want made on your behalf? When is life worth living to you? And when is it time to literally pull the plug? When is that time? When do you identify that time? And that's not part of a trust. It's a part of a comprehensive estate plan, but it's not part of a trust. So let's talk a little bit about unclaimed property. Does anyone have any idea how much money is in our State Department of Unclaimed Property right now? It's over $700 million. And a big part of the way that that money gets there is that somebody passes away and the heirs, the kids, whoever it is that came behind them, wasn't aware of all of the different accounts, wasn't aware of all of the different places that that person had assets. And so maybe they didn't know that there was a bank account out there, and maybe they didn't know that there was some stock out there or some dividends that hadn't been cashed. And what ends up happening is that money gets missed and it ends up going to the Minnesota Department of Unclaimed Property, and it becomes very difficult to claim later on. It becomes very difficult to actually claw that or to get that money out of the Minnesota Department of Unclaimed Property and make sure that the right people are receiving it. Again, this is totally avoidable. That I encourage people to create an inventory. And for my clients, we actually will create together an inventory of your assets so that people are aware after you've passed away exactly where you did your banking, what they should be looking for, who they should be talking to make sure that all of your assets are claimed and that they're going to go to the right people. Oh, and this is really cool. We've talked about a trust, and we've talked about how you can make sure that your assets are in your trust. One thing that you can do with your trust after you've passed away and your successor trustee steps into your shoes, that trust is now irrevocable. That the rules that you wrote during your lifetime apply to that trust and they can't be changed anymore. The rules can't be changed. And that inheritance that people will receive, whoever you want to receive it, you can add something over that inheritance called asset protection. And this is so cool. I'm able to do this in the context of our estate planning together, that we're able to build it into your trust so that the assets that you had in your trust during your lifetime or that were funded into your trust at your death are protected from things like divorce or creditors. We can build in protection in case somebody is suffering from substance abuse, so that a trustee can protect those assets and secure those assets and make sure that they're used in the best way possible. It's very cool. Again, we can protect those assets from a divorcing spouse or creditors in a bankruptcy, which is not something that you can do on your own, not something you can do with your own money, but it's something that you can do with an inheritance that you're giving to somebody else. Planning for incapacity. This is very important. With the pandemic that we've all just gone through, I think we all know how important it is to have somebody who can make healthcare decisions for us and speak for us in case we need someone to speak for us. The person pictured here is Terry Schiavo. And many of us probably remember the story of Terry Schiavo back in the mid-2000s, that she was somebody who was in what some believe to be a vegetative state. Some people believe that she was still interacting with her surroundings. Regardless, there was an argument. There was an argument between her parents and her husband about whether Terry's life should continue. Her husband thought Terry would want to be taken off of life support. She should be allowed to pass. Her parents thought that she still had some quality of life and that Terry's life should be continued. Unfortunately, Terry Schiavo did not execute a living will, did not execute that second part of a healthcare directive saying what she wanted from her own healthcare. And so when she ended up in that situation, her wishes were unknown. And it ended up that a court had to decide what they thought her wishes would be or who they thought should be making decisions for her. They ended up siding with her husband, who took her off of the life support, and Terry Schiavo ended up passing away after being taken off of that life support. But before that happened, there was all kinds of conflict. There were court cases, and it was an entire nationwide ordeal about what was going to happen with Terry Schiavo. And that doesn't have to be the case. You can write down, you can record exactly what your wishes would be if you're in a situation like Terry's. And that really is part of a comprehensive estate plan. It's an essential piece of an estate plan. Make sure that you have that in place. So we've talked about a lot of things tonight. We've talked about probate, we've talked about guardianship for minor kids, we've talked about unclaimed property and estate taxes, and we've talked about planning for incapacity. And you're probably wondering, there's probably something in our conversation here tonight that sparked it in your mind that I need to get this done. My guess is you probably maybe already had that thought when you came tonight, but now that we've talked about it, my guess is that you're probably convicted that now is the time. I need to get this taken care of. I need to get this addressed. So the question is, what can you do today to do the right thing for your family, and what should a plan to cost right? And the options to create your plan are either to do it yourself or to work with an attorney. And keep in mind that not all attorneys are the same. So is estate planning something that you can do yourself? Is it something that you should be trying to do yourself? Well, I have kind of a guide here about whether you might benefit from working with a lawyer. But what I really like to do here, I like to tell a story. And the story is this, that my son and I were going to go fishing. And I had gotten us a couple of new fishing poles, and I needed to put fishing line on the fishing poles that they had shipped to us without fishing line on the reels, the way that they shipped. Okay, not a problem. I ordered some fishing line separate. The fishing line came, the fishing poles came, and I went downstairs. I was on the table, had the fishing pole on the table, and I had everything set up. I was reeling on the fishing line, and as soon as I got done and I went to snip the fishing line off, the excess fishing line off, all of a sudden, I don't know what I messed up. Maybe somebody can tell me here tonight, but the fishing line on the reel just started jumping off of the reel, and it created this huge tangled mess on the table in front of me. I still don't know exactly what I did wrong, but that's okay. You know, that was a story of a do-it-yourself project that I goofed up, right? I made a mistake on. I made some error in the process that made it not work the way that I wanted it to work. But that was okay, because the cost of that fishing line that was tangled and was a mess, and I ended up having to clip off, wasn't excessive. You know, maybe 30 cents a fishing line, maybe 20 cents a fishing line. It wasn't expensive. I was able to solve the problem without much cost. And guess what? I knew that there was a problem right away. I could see it in front of me. Something went wrong. And seeing it in front of me, I knew that I was the one who caused the problem, and I was able to address it, and I was able to take care of it right away. And I was able to take care of it right away. I didn't have to leave that problem for someone else. And I always tell this story because estate planning is the opposite of all of those things. If you do your own estate plan, I've heard people describe it as putting together IKEA furniture without the instructions, that it's very complicated. There are a lot of moving pieces, and you need to make sure that they all line up and that everything is in the right place so that it's going to work the way that you want it to work. And if you miss something, if you miss anything, then you have a chance of it failing. And guess what? If it fails, it's not going to cost 20 cents or 30 cents to fix. You're going to need lawyers to fix it, and you're going to need court processes to address it and to try and create some semblance of order. You're not going to know whether your estate plan worked or didn't work. That's not something that you're going to get to find out. It's something that your family is going to need to find out after you're gone. And you're not going to be there to fix it. That they're going to be grieving, they're going to be in a hurting situation, and trying to put the pieces back together, and trying to deal with what the remains are there. And that's why I understand I am biased. I'm an estate planning attorney. I have people pay me to do this work. And so clearly I'm a biased participant in this conversation. But let me tell you, I've seen it go so wrong. I've seen people get the wrong legal description on a transfer on death deed, and it cost thousands of dollars to get that deed fixed after somebody's passed away. I've seen people fail to record transfer on death deeds, and I've seen the expense of not having that transfer on death deed recorded. And now all of a sudden there needs to be a probate where there wouldn't have needed to be a probate if you'd have had an attorney involved from the beginning. And I've seen people who have tried to do it themselves and do their own trust or do their own will and make mistakes. And maybe the mistake is you didn't put all of your assets in the trust. You didn't fully fund your trust, which is something that an attorney should be overseeing and should be guiding you and helping you to do. And in that case, it's not going to work the way that you want it to. And if something gets missed, that something could mean that your estate has to go through probate, even though you almost did the right thing. You almost got there. It can be very expensive. And I just want to encourage you, for most people, you would benefit from working with an attorney. There are some exceptions. If you have less than $75,000 in assets and you don't own any real estate, then it's possible that you could get away with doing an estate plan on your own. But I know that that applies to very few of us. And if we want things to be simple, if we want our families and our friends and the people that we love to avoid court and to avoid conflict, then it's very important to have consult with an attorney to get an estate plan written. And I always say, as a little asterisk on here, if you want to give your assets to someone other than your kids, it's pretty important that you work with an attorney to make sure that that happens and to make sure that the court is going to honor your wish and honor what you want to have happen. Keep in mind, again, not all attorneys are the same. And again, I want to bring you back to this quote that wasn't said about me, but it was said about another estate planning attorney that somebody had worked with. Someone has to graduate at the bottom of the class. And again, this frustration wasn't about that attorney's actual intelligence or that attorney's actual knowledge, but it really had to do with the way that they were helping somebody plan and the things that they weren't taking into account as they were writing the plan. And I really call that experience that typical estate planning experience with a typical estate planning attorney. I call it planning for death. And it really includes things like form documents that the attorney might fill your name in on, but that's about it. That's about all that they're changing in the document. And then they hand it off to you, and maybe they don't really understand it all that well, but they certainly don't guide you along in the process, and they don't help you to understand exactly what's in that document and what it means and how it actually gives you exactly what you're looking for, exactly what your estate plan should be doing. And that means that you probably put it down in a bottom drawer in your desk and you don't look at it again. And 10 years go by or 20 years goes by, and who knows if it's going to work at that point. So many things can change, even in 5 years. Who knows if your estate plan is going to work the way that you want it to after that amount of time has changed, if you don't have an attorney who can review it and tell you what it means. Typical experience isn't going to keep money out of the Minnesota Department of Unclaimed Property. That's just not a concern of most estate planning attorneys. They don't see it as part of a comprehensive estate plan, which I do. Typical experience may avoid probate, but it may not. In fact, I happen to know a lot of estate planning attorneys plan for probate. And they plan for probate because that's another way that they make money. And so they know if they just write you a will, that when 20 years down the road, whatever the timeline is, you end up passing away, they're going to get to help that family with probate, your family with probate at that time. And they'll have the added fees coming from that. I can tell you, I help with probate. I've never had to probate a client's estate plan or a client's estate plan that I've written. And I hope that I never do, because I don't like probate. It's just not fun. It's working with the courts, and it just is a slog, and nobody's happy by the end of it. I do see that we have a question, and I'll answer it in just a minute, but I just want to continue with this first. Typical experience probably isn't going to keep your family out of conflict. Again, that's just not what most attorneys are focused on. Most attorneys are just focused on the assets, the money, and they're not focused on things like your stories or your values that you want to share with the people that you love. Typical experience is going to leave assets to heirs unprotected. Very few attorneys are doing asset protection planning for the next generation. It's just not something that most estate planning attorneys consider. Typical experience isn't going to provide ongoing legal guidance. And the reason is that most attorneys charge hourly fees for the work that they do in planning your estate, and then plan to charge hourly fees for any time that you contact them in the future or need to update or need to work on your documents or need to ask them questions in the future. Typical experience doesn't adequately protect kids, minor children. It might plan for long-term care, but it doesn't for the long-term guardianship, but it doesn't necessarily plan for that short-term guardianship. Really, the typical experience leaves you with this question: is this going to work when I need it to work? And that's not a question you should ever have after you've worked with an attorney to plan an estate. Planning with me, on the other hand, is completely different. It's planning for life, and it's a completely different experience. For one thing, I charge flat fees, and I work with my clients to choose the flat fee in the package that fits them and fits their family and fits their finances the best. And I'm willing to work with you. I'm willing to find ways to build a plan that is going to work for you and work for your family in the best way possible. Planning with me means that you can keep your money out of the hands of the state. We plan to minimize estate taxes. We plan with an inventory to make sure that people can find all of your assets and make sure that all of those assets go to the people that you want them to go to. It protects kids totally if you have minor children, because I do not only the short-term guardianship, but the long-term guardianship as well. It keeps your family out of court and conflict. And I really think that's one of the biggest things is people come to me and they say, I want things to be as simple as possible. And that's what I'm trying to deliver on here. I want things to be as simple and easy as possible for the people that you're leaving behind, because I know that that's what you want as well. Planning with me means knowing that you've made the right decisions. And the reason for that is that I bring you along on the process and I teach you. I know a lot about the law here in Minnesota. I know a lot about estates and estate planning provisions and what they can do and what they can't do. And I can give you that information. I can educate you and guide you to the questions that need to be answered so that you can make the right decisions for your family and for your assets and for the people that you love. Planning with me means protecting the family money from outsiders with that asset protection that we talked about. Planning with me means a lifetime of guidance and protection. I'm not going to charge hourly fees in the future for ongoing legal guidance. If there are changes that you need to make to your estate planning documents, unfortunately, I do need to charge for those because I don't know what the future holds for you, and I can't roll all of that into just one fee. But future communications, updating your plan, reviewing your plan and seeing if it needs to be updated, all of that's included with me because it's all an essential part of making sure that you know that your estate plan is going to work when you need it to work. And that really goes to this question that I have here. How often should a living trust be reviewed and updated? And does this cost each time you review? No, there are no additional costs to reviewing your estate plan, to reviewing your trust, making sure it's still doing what you want it to do. If there are changes that you want to make to trustees or who's receiving under the trust, if there are changes to your documents, unfortunately, I do charge something for those, but I promise it's always going to be a reasonable fee. We'll come to an agreement on what flat fee is acceptable before I start doing any work. And I promise you, it'll be reasonable and we'll find a place where we can agree to work together. Again, planning, you want to know that your plan is going to work when your family needs it the most. And the best way to think of estate planning is that you are giving a gift to people in the future. You're giving a gift to people who need to make healthcare decisions for you. You're giving a gift to people who need to deal with your finances and deal with the bank and deal with your creditors and make sure that that's handled in the best way possible. And you're giving a gift to people who are receiving your inheritance or an inheritance from you so that they're receiving that inheritance in the simplest and cleanest way possible without conflict, without court. And so what should this cost? Keep in mind that if all that you have is a house that's worth $400,000, and I understand for a lot of us, that's a very nice house. But if all that you have is that house that's worth $400,000 with probate costing something between 3 to 6% of the gross value of your estate, you'll be saving at least $12,000 with this planning. And that $12,000 is 3% of a $400,000 house. If you have assets over $3 million, then this planning is going to save your family 13 cents on the dollar for every dollar in excess of $3 million. That's the estate tax exemption amount here in Minnesota. A typical death plan with a typical estate planning attorney is going to cost at least $1,500. It's a $1,500 minimum. If you find somebody who's asking less than that, then they're doing extremely shoddy work and quick work and not even doing the basic foundational things. I would guess. I don't always know that, but I would guess that the typical plan that you would see, the lowest level would be about $1,500. And you can be almost guaranteed it's not going to keep your family out of court or conflict. It's not going to ensure that your assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your monies, not your kids' immediate care or your values, insights, stories, and experience, those most valuable intangible assets that are often the most lost assets. And the alternative is you can meet with me. I'm a personal family lawyer, and that means I've dedicated myself to practicing law and to practicing estate planning in a very specific and a very special way, where I'm dedicated to taking care of my clients and giving them the best results possible every time. You can choose your own fee, and that fee generally ranges somewhere between $2,000 and $8,000. The typical fee package, the typical plan with me, a typical trust plan would be about $4,000. And I would say that that's probably the average fee that I charge, is about $4,000 to get a great estate plan in place that's going to take care of the people that you love. I do see a couple of questions here. Let's say something happens to me. What happens to the estate plan? That's a fantastic question. If something happens to me, I have an agreement with another estate planning attorney. He's agreed to take on my clients if something happens to me, and I've agreed to take on his clients if something happens to him. The longer version of that answer, though, is if something happens to me, your estate planning documents are still going to do what we designed them to do. And so any estate planning attorney in Minnesota, you can bring those documents to that attorney. They can read them and understand them. And when you do pass away, or if you become incapacitated before you pass away, they're going to be understandable and they're going to be legible to any estate planning attorney in Minnesota. Another question here. So for the estate planning for a house, if I buy a new house, does that mean I would have to renew the estate planning, new address? That's a fantastic question. I would say if you buy a new house, you want to make sure that you take title to that new home in the name of your trust. And that's something that isn't going to cost you anything extra. I encourage my clients all the time to call me if they're going to buy a new house, and I can make sure that your title company has the name of your trust so that they take title. But yes, your address is included in there in some documents, certification of trust, but it's pretty minimal. It would be, I would say, I wouldn't encourage people to update their entire estate plan just because they change an address or something like that. That it's something that we could review, and we could select what we need to change and what we need to update. And I just want to share this with you. I want to make this really simple for everybody. I want to make this really simple and easy and accessible. And the way that I want to do that is by giving you an offer. And the offer is this. First off, I want to have a meeting with you. And I want to have what's called a family wealth planning session with you, where we will look at your specific situation. We'll look at your assets. We'll look at the people that you love. We'll look at your family. And we'll talk together about your situation and what probate might look like for you, and how we can make sure that probate is avoided or at least minimized in your situation. That family wealth planning session is a planning session with me. It's a strategy session with me. It's 2 hours long. In the first hour, we're just going to talk about your situation, and we're going to talk about what would currently happen. Maybe you have an estate plan in place already. That's great. We'll look at your current estate plan and we'll say, this is what it says. This is what's going to happen. If you don't have an estate plan in place, again, Minnesota has written an estate plan for you. And we'll look at that estate plan that Minnesota has written. We'll look at the laws, and I can tell you exactly what's going to happen. And we'll look at it together and we'll say, this is what it says. This is what's going to happen. If you want to make changes, we'll talk about exactly how we can make those changes. In the second hour, if you want to hire me, if you say, yes, there are changes that I want to make, I want to take care of things, we'll start that second hour by talking about pricing. We'll talk about exactly what it will cost to plan with me, and we'll find something that fits you and fits your family and fits your finances the correct way. And then moving into the second hour, we'll actually start planning your estate together. We'll start drawing out what your will looks like or what your trust looks like, how assets are going to go to the people that you love in the simplest, easiest, and most affordable way possible. Seeing here, family wealth planning session is free. Yes, the family wealth planning session has a $750 value because it's 2 hours with me, along with some preparation time that I have to do ahead of time. And so it's very valuable, but yes, it is absolutely free. I want to give that to you absolutely free. And what I'm trying to do here is just lower the obstacles to getting this process started. This is what I see so often, is that estate planning is a momentum thing, that it goes onto our to-do list and then it drops down our to-do list and eventually falls off, right? Nobody wants to think about this. Nobody wants to think about death and what happens after they're gone. It's something that we all need to have, but I completely understand. It's something that we don't want to think about and often falls down our to-do list and eventually gets left off. But what I want you to do, I want you to click through the link that I just put into the chat, scan the QR code, type in that URL, however you want to get there, and take a look at my calendar, find some time that you can schedule that family wealth planning session with me. Again, absolutely free. I want to give you that free for attending here today. And in addition to that family wealth planning session, I want to give you $250 towards the estate plan of your choice if you reserve that appointment before the end of the week. Doesn't mean that the appointment has to happen before the end of the week. It just means I want you to get on my calendar and to reserve that appointment by the end of the day, Saturday. That's your timeline. That's what you're looking at. But I absolutely want you to have that. I want you to have that meeting with me. Again, lowering the barriers, lowering the obstacles as much as possible so that you take that next step with me. Get into a meeting with me and let's talk. Let's find out if you have an urgent estate planning need. Let's find out if we can make it affordable and accessible for you, and something that we can make work into your finances and work for your family. And if it is, fantastic. I also want to make it even more affordable by giving you $250 towards the estate planning package of your choice in that meeting. I see some other questions here. Is it any less for a single person, no kids, under $800,000 in assets? I encourage you, sign up for a meeting. Probably will be the same, that these are set fees that I have across the board, but we can talk about it. And maybe things will be simpler in your situation. Maybe there are some simpler estate planning options that we can look at. I promise you, I'm not looking to charge top dollar, give everybody the absolute Rolls Royce estate plan. I want this estate plan to fit you, and we'll talk about it together. And we'll talk about if there are some simpler options that we can look at, ways that we can make it more affordable and more approachable to you. I'm absolutely all for that. I want this to fit your finances, to fit your situation, fit your family in the best way possible. How much time does it take for me to prep for that meeting with you? What do you need from someone who meets with you in the family wealth planning session? Fantastic question. There is a form, there's some homework, pre-work that I will send you ahead of time. And I really need that information for our session together to be effective and for me to be able to give you the guidance that you really want and that you really deserve. And so there is some pre-work that I'll have you do. It's collecting information about your family, about you personally, and then some information about your assets as well. It doesn't have to be super precise. If you can kind of fill in bare bones for me, we can go into more detail when we actually meet in person. But I do need to have some guidance. I need to have some idea of things so that we can have an effective conversation together. Without a trust, would my minor child be forced to go live with my ex? What would happen to my home? So generally what would happen if you don't have any estate plan in place at all and you have a minor child, that minor child is going to have a right to receive everything at the age of 18. But before the age of 18, they're going to have, they would be the natural recipient of your assets, of your estate. And as the natural recipient, they can't actually hold those assets, but they can have somebody hold those assets on their behalf. And that person is called a conservator. And the most natural selection for a conservator for your minor child would be your ex-spouse. That would probably be the person who is holding your assets for you and was making decisions about what needed to happen with those assets. Your home would probably be sold, and the proceeds from that home would be held in conservatorship and would at least be able to be used for things like educational expenses and health expenses of that child, living expenses for that child. But that's probably what you can expect. That's probably the most likely situation if something happened to you and you had a minor child with your ex. So yes, probably have to go live with the ex. I don't know your exact situation. If you want to know more, I encourage you to come and meet with me, and we can draw out exactly what that looks like, and figure out if we can find a better solution than having your child go live with your ex, having a conservatorship placed over the assets for that minor child, and having that expensive process in place. I'm sharing with you here some information about me, some information about what it's like working with me. These are some things that clients have said about working with me. I'm a little too embarrassed to read them myself, but hopefully they'll be helpful to you, give you a little picture of what it's like working with me. See someone saying here, thank you, my life insurance would pay off the house. I will schedule a time with you. That's fantastic. I'm really glad to hear that. And I'm really looking forward to meeting with you. I hope that more of you will schedule. I hope everybody here tonight will schedule. Again, I'm offering a completely free meeting with me. And the reason that I'm doing it, I want the barrier to be as low as possible so that you take the next step as soon as possible. I want you to take the next step tonight. I understand if you need to coordinate schedules with someone that maybe you can't book tonight, but I hope that you'll book soon. And I will follow up this meeting, this webinar, with some emails. I'm going to email out the recording of this webinar. I'm going to email out the link so that you can see my calendar. And I see somebody saying, thanks, TJ. Absolutely happy to have you here. Very happy to have you here. And thanks for joining me here tonight. So next steps, please schedule that free family wealth planning session with me. I really encourage you to do it, and do it soon so that you can use that $250 towards the estate plan of your choice. Can I send a recording to a friend who couldn't attend? Absolutely. Yes, absolutely. And if they watch the recording, I will absolutely give them the free family wealth planning session with me. I'm very happy to do that. Thanks. See you at my appointment. Fantastic. Great. I'm glad to see you there. I'll be glad to see you there. Someone else says, thanks so much for educating us. Happy to do it. I don't believe that this is sacred information. I want to share this information. I want to get the message out there so that as many people are as educated as possible. Thank you so much for this information. I will be contacting you. Fantastic. I'm really glad to hear that. Happy to help. What if they're out of state? So unfortunately, I help people here in Minnesota. I help people in Minnesota plan their estates. I do have connections with attorneys who are in other states. We can operate in a couple of different ways. Either I can make a referral to somebody in another state, an attorney, an estate planning attorney like myself in another state, or if they really want to work with me, if they've heard such good things about me, and we have such a connection that they really need to work with me, then what we can do is co-counsel with an attorney in another state to make sure that they're getting an estate plan that is tailored to their state and takes advantage of the laws of their state as much as possible. But we can make sure that that I'm able to be the point person and help them to plan the estate and guide them through that planning process. Someone saying, thank you, this was informative and comfortable. Oh, fantastic. I'm really glad to hear that. Try and be approachable and allow people to ask their questions and receive answers. So I'm really glad to hear that, that it's informative and comfortable. I'll wait online here for just another minute to see if there are any other questions. In the meantime, I'm going to go ahead and post the link that I had from before. And hopefully you've had a chance to click through and take a look at my calendar. I don't know where we're currently at in the calendar. I know that the selections for August were limited before tonight. You may be looking, you may need to click into September. but I know that I have great availability in September and October. And so I hope that you can find a good time to meet with me in the near future. And we can have that free meeting. You can use the $250 towards the estate plan of your choice. Again, I'm going to hold on here for just a minute. I just want to make sure that people can get the time and find some time on there that they can schedule their appointment before we call it to a close this evening. And if anyone else has any questions, again, always very happy to answer questions. I know that it's not, you don't always have a chance to pose those questions to an attorney and hear a direct answer. Last question, can a minor be a part of a joint tenant? My assumption is no. Generally, no. Often what I'll do instead of having a minor be a joint tenant, you can include a minor on something like a transfer on death deed. And then you're just hoping that you get to the point, you're hoping that you get past them being a minor and they're no longer 18 and can actually receive the asset when it ends up going to them. A joint tenant, they would be actually holding onto the property. And so that would be not good, but having them as a transfer on death designee, that transfer doesn't actually occur until the death of the last grantor owner. And that's why having a transfer on death deed works a little bit better. Absolutely, I can post the link another time. In fact, I will send it to you directly here. And I did put it in the chat again. Transfer on death deed or transfer death deed. Does that mean they will have to pay for the mortgage even when paid off? Unfortunately, yes, the mortgage doesn't go away after somebody has passed away. And that's a good thing and a bad thing. They can assume your mortgage, which means that they don't necessarily have to qualify for financing themselves. But unfortunately, yes, that's a secured loan. It's attached to the property. And so the mortgage does have to be paid. It doesn't go away when somebody passes away. If the mortgage is actually paid off, we'll have to pay for the mortgage even when paid off. If the mortgage is paid off, then there's no mortgage that goes to the person who's receiving by a transfer on death deed. The property wouldn't be mortgaged anymore. There's only the mortgage would only go to the beneficiary in a transfer on death deed if they in that situation where there's already a mortgage on the property. All right, hopefully I answered that well enough. I see somebody has their hand up and I am not sure if that's intentional. If you want to be permitted to talk, that's theoretically something that I can do, but I would rather, if you don't mind putting in either the chat or the Q&A box your question, I would prefer that. But if you put, I just don't want to permit somebody or open up somebody's microphone when they didn't want to be permitted to talk. They didn't want to be able to talk. So I see here, can you do a transfer on death deed to a trust? Yes, you can. The place where that is less advantageous is that that I usually do what's called a quick claim deed to a trust, which immediately transfers the house into the trust. If you do instead a transfer on death deed, that's fine. Then it would transfer after you've passed away to the successor trustee and be held in that trust. And that's okay. But the situation, if you became incapacitated during your lifetime, the only person who would have access to that house with a transfer on death deed on it would be somebody under a power of attorney. And that might be okay, that somebody under a power of attorney might be able to deal with the property if it needs to be dealt with. For example, if it needs to be prepared for sale. But it's generally much easier to have a successor trustee dealing with the property instead of trying to get a power of attorney in place to deal with that property during your lifetime. The power of attorney is something that we work on and something that we do as a part of a comprehensive plan as well. So, so yes, it is possible to use that transfer on death deed to put the home into your trust at your death. Any other questions before I go ahead and end our session here tonight? All right. Well, I really appreciate everybody joining me here tonight. I really appreciate the questions. This was a very active group and I absolutely loved it. I'm very happy to answer your questions here tonight. I'm hoping to see many of you in family wealth planning sessions here in the near future. Again, I really enjoyed meeting with you and I hope you have a great rest of your night. Take care.